You are watching DHTV from California State University, Dominguez Hills.
Hi, I'm Dr. Pamela Kreiser, and welcome back to NCR 525, which is our course about mediation. Today we're going to finish the last stage of mediation, and we call that stage 5. We're going to talk about all of the stages and then some of the things that we need to accomplish in stage 5. And then we're going to talk about online dispute resolution, and then finally finish up with an interview with my friend and ADR administrator, Barry Roberts. So let's start with talking about the stages of mediation, just to provide some context. Now, previously we've identified that in the first stage of mediation, we do the opening statement, we do confidentiality and the agreement, we set the ground rules. Then the second stage of mediation, we're doing storytelling and issue identification. On the third stage of mediation, we are building the agenda. On the fourth, we're going to generate options. So we'll do problem solving and negotiating. And then on this fifth stage, we're going to actually get the agreement and write it up. Now, one of the things to know about today's show is that I'm going to talk about stage 5 theoretically. But later, I will also give you, for the class purposes, I will give you another video to watch that will go through some of the specifics of writing the agreements. So we're going to talk generally about stage 5 as we do it from a theoretical standpoint. So we're going to talk about stage 5 first by looking at this video by Peter Adler, and he talks about what is happening in mediation from his perspective.
The core principle of mediation that most enthuses you from your perspective is what?
Well, I have to say that I'm quite interested in problem solving. I know those are bad words. People don't like to talk about that anymore. But I actually feel like $1 million when people get together who are skeptical, critical, or engaged in a real ruckus and are able to make some forward momentum on taming tough problems. And the area that I've worked in primarily has been energy, environment, public health, social policy, and in finding traction in those areas. And that's part of what brought me to Keystone. And I continue to like that a lot. I like that. I think that it is one of the most constructive uses to actually help people move forward and get unstuck on
What
something.
I'm hearing, though, is within that core, and we'll talk more about those pieces, is the idea that people might be able to, insofar as possible, do that for themselves, as opposed to
so.
Other people doing it to them for them.
Yeah, I think that's right. That's the impulse. That's the imperative, is that people can negotiate their own solutions. They can talk with each other. They can communicate in some civil way, even though they're angry, even though they're hurt, and they can work their way through those strong emotions, those very powerful emotions that attend conflict, and come out with solutions that they construct themselves. It's always been the hope.
Now, it will be tempting for you as a mediator to think about statistics, because when you get to that fifth stage, you think to yourself, gosh, I want them to sign the agreement. I want to get this on the win column. But you have heard me before talk about this issue, and that is I would caution any mediator against thinking about statistics. Ultimately, we have to have the win or the lose be housed or reframed into the activity of mediating, not what happens in the mediation. Remember, that's sort of misunderstanding the idea of outcomes and process. Remember, the mediator owns the process and the disputant owns the outcomes. So if I put my stats on the outcomes, like did they sign, did they not sign, I could become very confused about my role as a mediator. And so, one, know your role, and then two, don't keep statistics on your success or failure. My argument would be just mediating at all would make you a success. Just the fact that you're working to help another human get to a better place, that seems like enough of a win for me in terms of the reasons I do things, or the motivations behind what I do. Now, we've talked about stage 4, saying that we are doing the problem solving and negotiation. So that's where, remember, we generate those ideas. And then often there's like a turning point that moves us going forward into stage 5. And so I want to look at this next example, which is a sample mediation that kind of shows us an example of this particular part of the mediation. Let's take a look.
Dr. Stanfield. Welcome back.
Thank you.
I'm pleased to tell both of you that it seems to me that we are making progress in this mediation. And I think if I can summarize, Dr. Stanfield, I communicated to Clive your willingness to tender an apology for what you said about him, and I think it would be very useful if you could do that yourself.
Would you like me to, in fact?
Yes, please. I think if you would.
Okay. Clive, I do regret having lost my temper and called you dishonest. I apologise for that, and hopefully we can put that behind us.
I accept your apology and thank you for saying that. It takes a lot of courage to say that, and I accept that.
Okay.
And you, Clive, you also mentioned to me that you felt that Dr. Stanfield was a good man. Perhaps you'd like to
Yeah, I know.
on
There's
that.
no doubt. Our relationship was excellent, and I think that if we can find a solution here, we can maybe build on that relationship. The friendship and the business relationship that we could possibly work on. But it means a lot to me, the fact that you've apologized for calling me dishonest, and I respect you. I want you to know that.
Thank you.
Well, I'm happy to tell both of you that I put the proposals that you had, the options that you mentioned, Dr. Stanfield, to Clive. Clive, would you respond to the third one? Don't worry about the first two for the moment, but the third one, which entailed perhaps yourself and Dr. Stanfield working together going forward.
Yes, I think. Can I call you Joe?
You may with pleasure.
Thank you, Joe. I think that what I would like to see is that we find a way to take this very exciting product into South Africa, into Africa. We could do very well doing it together, and some form of partnership between us. I can put the capital. I need your medical experience of this as well to promote this product. I see synergy between this product and your dream about the sporting industry, working in the sporting industry, helping sports people. So what I would like to see is us take this brand, build it, develop it, and take it into Africa together. But I do have a condition to that. I can't have Sue around. It's just not going to work for me. The trust between us is just gone. So that's going to be the only condition to that, is that Sue is not in the picture.
Would you like to respond, Dr. Stanfield?
I have no feelings one way or the other as far as Sue is concerned, except that she seems to have done my books in a very nice way. I'm not sure why you don't want to have her involved, but that's your prerogative. What I would just like to clear up in my own mind is I actually don't think that Sue's been the architect of anything that has happened here, and I think that she's been quite honest from my side. But if I take a step back and say, is that going to be the impediment to turning this business into a successful venture, then providing that Sue's correctly treated in terms of basic conditions, etc., then that's a business decision that we have to take.
Yes, I don't want the thing to be all about Sue, this dispute and this potential between us. So I'm going to, maybe I have allowed my emotions to form my opinions, and I have maybe jumped to conclusions about the accusations of theft, and maybe that's just not the case. So yes, the only thing I want you to acknowledge is that my relationship with her is broken down completely. I can't work with her. So what I hear you say is that you're prepared to, you accept that. And for that reason, I want to congratulate us and thank the mediator for helping us solve this case today.
Right.
If I may ask, going forward, you the businessman here, what would your proposal be, or how would you see this being structured?
Yeah, I think there's going to be quite a bit of negotiation still between me and Joe in terms of the roles that we're going to play in this business, to what extent he's going to be involved. So, I mean, I think that on a long-term basis, I probably would require a doctor involved in the business. But I'm not going to require him to do the business side of things. I'll do the business side of things. I'll do the business plans. I'll do the rollout. It probably makes sense for us to enter into some kind of a JV or partnership agreement so that our roles can be specified, and also our expectations from the business.
How do you feel about that?
Providing that it's
Okay.
in concert with the Health Professions Council's ethical rules, which I'm bound to, that's fine. I'm quite happy that you handle the business side. There are very specific constraints by HPCSA. We'll look at those together and make sure that
Absolutely.
the
that's-
business and I abide by them. Then I'm happy.
Thank you.
If you're in a partnership or a joint venture, it might be useful if we record in your agreement a basis. I'm not suggesting that you need to agree that today, but do you have some sort of a basis in your mind that you would be prepared to put on record, or would you like to rather think about this more?
Well, I mean,
in terms of partnership sharing?
Yeah, I think that it really, I think there is, we need to you know, I'm going to be putting in the capital for the business. So I think in terms of partnership sharing, I probably would, look, I think I'm prepared to go on a 50-50 basis. If that's good enough for you, we could work on that basis.
I stress at the moment, we would have to look at this in terms of HPC, because I can't share with you as a medical practitioner. I'm not allowed to share with you as a partnership in a medical business. But there are certain ways that
We can do that.
HPCSA allows,
Okay.
franchising, etc. So we can certainly
You
look
can
at
work that out.
There are ways
We
to
could make
look
that
at
a condition,
Absolutely.
but it seems to me that then, gentlemen, you have an agreement, and we've reached the stage where perhaps we can reduce that to writing.
Yes.
And you can both sign it.
Thank you very
My
much.
My congratulations.
Thank
you.
Really well
Thank you.
done.
Thank you very much. Thank you very much.
Good, guys.
Thanks.
Good luck with you.
So as you can see from this example, they have been able to get to the point of an agreement. And of course, this example isn't perfect, but it provides us with a little bit of insight on what happens in stage 5. And that's where the parties do end up forming an agreement, we hope, and then they can move forward. But the one comment I would make is we have to understand what goals we're accomplishing in stage 5 to be able to execute that on the mediation side. So the first thing we're going to do is put the agreement in writing, and you heard them moving from that particular conversation now to putting the agreement in writing, then list each issue and test it, then read and sign the agreement, and then thank the disputants and close the mediation session. So what I want to do is talk about each one of those goals that needs to be accomplished in stage 5 so that from a theoretical perspective, we have a really good handle on what needs to happen. So the first comment that I had made in terms of goals is that we need to put the agreement in writing. And this is where it really forces us getting down to the level of detail that's important. I like to say to myself, I'm going to give them such specific information that they'll be able to execute this if they can sit down, a week from now and read it and know what to do. So in terms of how you're describing the details and defining things, I would strongly encourage you to put down all of the specifics you can think of in order to help those parties go forward. And that's really what you're thinking about in terms of the writing. So let's say, for example, the parties agree to settle in the amount of $1,000. That's maybe what you're writing. I'm going to give you a different video about more specific information. But let's say the settlement is this. Parties agree to settle in the amount of $1,000. The defendant will pay the plaintiff in the form of a cashier's check in the amount of $100, and payments will be on the first of each month in 10 equal payments starting on June 1st. Now, if you think about it, there's a lot of specifics that I've just laid down. I've said the amount, I've said how it's been divided, when the payments start, what the format of the payment is, all of those things. However, there are some holes, and you might be thinking, wait, I don't know what those holes are, like what are the parts that won't work? And that's where we get to the second part of the goals of stage 5, where we say we're going to go through each item, even the parts that I listed, and make sure that they work and that they'll be durable in terms of can they be executed by the parties? And so, for example, one of the questions that I might ask if I were navigating that mediation, I might say, what do you all want to do on New Year's Day. And they might say, oh, we forgot that that was the first. But that's one of your goals as a mediator, to go ahead and look for any part of it that you think won't work. I might even say that to the parties. Do you think any part of this plan won't work for you guys? Do you think there's a part of this plan that won't work out in terms of timing or format or payment? So one is, what do we do on New Year's Day? And sometimes people will actually change the payment date on a holiday specifically. Another item that might be inherent to where you're mediating is to look to add a grace period. And that might be something to ask them. Do you want to have it be a certain date, or do you want to have a grace period associated with this payment? One comment that I would make that is a phrasing technical piece of advice that I would give everyone writing an agreement is, you don't want to say the payments will be made on the 1st. You want to say they will be made by the 1st. And that reason is that sometimes things can't happen on that day or on that hour. And so we say by that particular hour, meaning that we've indicated the outer barrier or outer boundary for whether that has happened or not happened. The other comment that I would have made about that agreement that I read to you a minute ago is, what about that cashier's check? Like, how will that be delivered? And who will that be made out to? And what will be the parameters on getting that to the appropriate party? And so that, I think, is pretty interesting to ask about too. And so as you ask about these items, then you can get down to the specifics. Now, when I mediate, what I do is, when we get to an agreement, I will sketch out some of the details before I go to the writing phase. So I'll say, okay, we have 10 equal payments, they're $100 each, cashier's check, and I'll ask right there, when do you want to do the payment? What format do you want to use? What could go wrong with that? What do you want to do about New Year's Eve? The other comment that I would also tell you from experience is, I won't just say 10 equal payments starting on June 1. I will say 10 equal payments on the following dates, and I will indicate the date and the year. And that is very important. I do know a story about a mediation that happened a couple of years ago. It wasn't my mediation, but the mediator inadvertently just said 10 payments for the total amount. And so the party who was paying wrote a check for 1 cent for the first 9 payments and then paid the entire amount on the last check. I know, people do that kind of thing. And so the mediator had failed to say equal payments and failed to specify the amount for each payment. They just said there'll be 10 payments totaling this amount. And so that disputant took full license and stayed within the mediated agreement, but still, I think, aggravated the other party for 9 months over it until the final payment was made on the 10th month. You get the idea. So we test the components, and then we put them in writing. You're as specific as possible, and we're going to talk about that even more in the next video. And you're trying to think of everything. Now, once in a while, you might forget something. So just be forgiving to yourself and say, you know what, if I forget it, then I'll talk about it with the parties when they come back in the room. So when I negotiate that final agreement, I'll get the details of it. Then I will excuse them to go outside of the room while I write it up. And so that's when I'm putting it in writing. Thankfully, where I work in the courts, there is a computer, so we can type those up, which is much faster than in the old days when we used to write those up. Because if you make a mistake, then you have to go back and do the whole thing over, which I have definitely done, because I've definitely made mistakes. So when they come back in, we're going to do the part where we read and sign the agreement. So after it's all been done, and usually after that stage happens, I will go to my court coordinator and show them the agreement so that that court coordinator can review it and put their initials on it and sign off that they believe it'll work. It doesn't mean they believe it works because they heard the case. They mean like it's in the language that has the appropriate format, that has the expected parameters, those kinds of things. So then I'll call the other parties in to the mediation, or I'll call them one at a time, depending on whether we're shuttling or we're doing a joint session. And they will come in, and I will read through the entire agreement. Then I will hand it to each party, where I hand them the document and say, please take a look and make sure this represents what you believe we have accomplished here today. Notice my very neutral phrasing, because I don't want to say, is it a good deal or a bad deal, or is it fine? I just want to say, does this represent what you believe we've accomplished? And then I'll do the same thing for the other party. The other thing I'll do when I do the agreement is you'll often see me, if you saw me in court, you'd see me actually point to the line where they sign. So what I've learned over time is that people do not sign in the correct place. Sometimes we have to redo the whole document because of this. So what I will do is point my pen to the line, even though it might say their name or plaintiff or something that we would find to be obvious. My experience is, because this is such a foreign experience, because people don't go to mediation that often, they aren't sure what to do pretty much at every stage. And so when I hand them the agreement, will say, if you agree, then you'll sign here, if you believe this is the document that reflects what we've accomplished here today. So when we get the signed agreement, then we're going to make copies. And then what happens next in the court that I serve is we walk everybody down to the courtroom, or we ask parties to go to the courtroom and we meet them there. And then we hand to the bailiff the 4 or 5 copies, depending on how many we need, to the bailiff. And then the bailiff will give those to the clerk. And then the case will be called up in front of the court, and the parties will be asked to come forward. And this is all something that I explain to my disputants before they get into the situation. So I don't just let all of this happen. I tell them about it ahead of time so that they're prepared. So what I tell them is, expect to be called. You'll go where it says plaintiff. You'll go where it says defendant. And you're going to go up, and the judge will ask you a couple of yes or no questions. Be certain that you listen to what the judge is asking you and that you answer clearly so the judge can hear you. Then the judge will go over the mediated agreement. So that means the judge will read the detailed agreement. That's what I've typed up. And they have already signed it. And the judge will ask them one more time if they agree to this being the accepted stipulation. The comment here is that if they do agree, this becomes the judgment on the case. Now, it doesn't mean that they are having the same consequences of the case, and we've talked about that, mediation versus adjudication, but that becomes the decision. And so that is an important part. So when I'm in the mediation office and we've done the signed agreement and everything's done, I make the copies, and then I say, here's what to expect next. And you heard me just describe that. And then I will also thank them for participating in mediation. I'll give them an evaluation form for them to fill out on my mediation services. And when I'm thanking them, by the way, I'm not overdoing that. I'm not saying thank you for doing mediation. I just thank them for trying the process, and that we hope that we provided good service for them. But we don't want to overdo it, because it just doesn't make sense to overdo that, in that we don't really need to do that. So those are the main processes that are goals that are happening in stage 5. Just to review, we talked about putting all of this into writing. We talked about identifying that solution and putting them to the test, list each issue, test it. We've talked about the reading and signing the agreement and how I actually execute that in terms of the paperwork and in terms of showing where to sign, that part of the process, explaining to them what will happen next, and then thanking them for their participation in mediation. And that really is essentially stage 5. As much as it can be time-consuming as a stage, it's not a very long explanation in terms of what needs to happen, but a very important part, because that is the final deal or the final written agreement that you're providing as a mediator. And so, of course, that can vary in length depending on how many issues. I find that when we do civil harassment, for example, often the expected behaviors that we write down are much longer than maybe, say, a civil case or as a small claims case. So anyway, that is a distinction that might vary the time length in terms of stage 5. Okay, so the next topic I want to talk about, I want to switch gears and talk about online dispute resolution. And this is something that we haven't talked a lot about in terms of this class, but it's something that I want to bring up because it is a big trend that's happening and continuing to grow. Now, some of you might say, gosh, that I am very skeptical about online dispute resolution. And I have some reservations, honestly, about it too. This is where we're using technology to help expand the reach of dispute resolution, and it comes in a variety of ways. So I've seen, asynchronous communication, which is where we just somebody emails back, right? We use synchronous processes, which is where we operate at the same time communicatively. So that might be a Skype collaboration, or something where we're on the phone or FaceTime, something like that, where we might use a mediated process in order to do our dispute resolution. We would also include that, or maybe collaborating documents. I've seen a number of courts move to offering an online dispute resolution program, and I think this is where we're going. But it is something that I think, because online is so expansive in terms of business, I think it's something we're going to have to probably think about in terms of mediators. So I have a special clip, or a series of clips actually, that are some conversations between Colin Rule and Bruce Graham. And these guys do work in online dispute resolution. Just a little background, Colin Rule used to be the director of online dispute resolution for eBay and PayPal. And so he used to facilitate that area. Now he's working full-time in online dispute resolution. These next few clips, they don't perfectly go together, but they do give you some insight into ODR, so I wanted to show it to you. Let's take a look.
You're the expert on ODR. I mean, you've written 2 books on ODR. You've,
Sure.
the director of dispute resolution at eBay and PayPal. Tell us, what is ODR?
Think of online dispute resolution is the use or the application of information and communications technology to the challenge of helping people prevent and resolve disputes. People traditionally think of online dispute resolution as an outgrowth of alternative dispute resolution, so that's mediation and arbitration. But I think what we found when we started to apply technology to the challenge of resolving disputes is there's a lot of other creative things that you can do. We can actually put these tools and techniques in place, and people can start to understand that, well, I have the responsibility, I own my issue. And these tools make it possible for me to come in, work it out myself, and that's the best possible.
Increasingly, corporations are putting into their contracts, you're going to go to mediation, we're not going to resolve this through court. So I mean, they're actually saying the judicial process is so difficult that we're going to put it into our contracts, that we're not going to use that if we have a dispute
I think you're
between
right about
parties.
that.
And I know our courts are feeling that a little bit.
Yeah, I think if you don't innovate, what happens is people start to look for alternatives.
Right.
There's a huge challenge in the courts with people that can't afford representation, or maybe the value of their case is so low they don't want to pay the cost for a lawyer. And they go into the courts and they don't understand it. They don't understand the language, they don't understand the process. And they end up going to the clerks and saying, what should I do? And trying to get legal advice, and the clerks are very uncomfortable about that. So it creates enormous churn and cost within the courts, and it creates a lot of frustration for the citizens
Right.
that are participating in the process that way. And I think it's a growing crisis. And I think a lot of folks in the justice system thought, well, how are we going to be able to tackle this?
I think there's a couple of different things. One's that we've seen with with JPs, kind of the lower jurisdiction courts. They want to work on the things that really are difficult. There's a whole slew of cases that come in front of them today that they feel like there's really not anything to decide here, and it's just clogging up their court system today. So they see online dispute resolution being something that could take a big chunk of those cases and have them resolved before they ever appear. I think for those that really care about the access to justice and what they feel like is fair, lowering the number of default judgments that are done today in all kinds of debt collection cases, landlord tenants. I mean, if you actually look at the data, I had one administrator here that told me last night, she said, I've gone back through hundreds of cases, almost. So what's been the reception of Modria? And has it surprised you? Has it been more than you expected?
Well, I was optimistic, but it exceeded even my optimism. It's to be talking to this level of influencers and decision makers, and to hear their enthusiasm for online dispute resolution, especially now that Tyler is backing it up and using, your rock solid technology platform to make it extend its reach and make it more stable. And, I think talking with chief justices and hearing about some of the challenges that they're wrestling with and how well the solutions of ODR fit in to addressing some of those challenges.
What have been the areas that have been kind of typically called out to you to say, this is the one we want to focus on, or we want to try this?
The main one, and I think this really resonates, is self-represented litigants.
Right.
I've heard this over and over again. There's a huge challenge in the courts with people that can't afford representation, or maybe the value of their case is so low they don't want to pay the cost for a lawyer. And they go into the courts and they don't understand it. They don't understand the language, they don't understand the process. And they end up going to the clerks and saying, what should I do? And trying to get legal advice, and the clerks are very uncomfortable about that. So it creates enormous churn and cost within the courts, and it creates a lot of frustration for the citizens that are participating in the process that way. And I think it's a growing crisis. And I think a lot of folks in the justice system thought, well, how are we going to be able to tackle this? So when you bring in these tools from the e-commerce side of the field and ODR, and you start to say, well, you know, every cell phone has the potential of being a point of access to justice. I think people get really excited about that, because I think I've said this to you before, I think this is the biggest opportunity we've had to expand access to justice in maybe a generation.
So as we can see from those clips, ODR is just kind of an exploding area. I loved what he talked about in terms of saying, is this ODR platform a way for accessibility to justice to be enhanced? And that makes a lot of sense to me. My only caution really when I think about it is I don't want to sacrifice quality. So when I think about mediation and like getting into deep conversations with individuals where needed, I would hate for us to sacrifice quality for the accessibility. So it's sort of like a breadth-depth kind of thing. I want us to retain the depth where we need it, but also have the breadth that they're describing in terms of utilizing ODR. Now, a couple of other areas to talk about. There's a couple of websites, iChatMediation.com, BidSettle.com. There are a number of different websites that are trying to help with these very simple cases and like make deals, which I don't know is really mediation. So it's kind of an interesting thing to think about in terms of our class. Like, is that really mediation, or is it really like a broader area of ODR that is really an ADR area? And that's just something to think about. It doesn't matter really where we classify. You know my opinion on classifications, only if they're useful. So anyway, that's some thoughts about ODR and some areas that I think we'll see really explode in the future.
You are watching DHTV from California State University, Dominguez Hills.
For the last section of our show, we're going to talk with our special guest, Barry Roberts, who is an ADR administrator, attorney, and mediator. Welcome to the show, Barry.
Thank you very much, Pamela. Glad to be here.
We are looking forward to hearing some lessons from you as a practitioner in the field. But we need to start by hearing about your background in ADR.
Well, my background in ADR started with community mediation at the San Francisco Community Boards. And years later, I got my LLM in dispute resolution from the Strauss Institute at Pepperdine School of Law.
Okay, so tell me what Community Boards was like.
Community Boards is a real community mediation center. We are trained in a particular type of mediation where we work in teams of three mediators working with the parties. And it's very much active listening, focusing on the parties' needs and emotions over and over and over and over again.
So question, who was coming at that time to community boards? Was it neighbor disputes? Like, was it neighborhood justice?
Yeah, exactly. It was a lot of neighbors. And often the police would refer their frequent callers to the community boards as well. So very serious problems with harassment and huge neighborhood disputes, that sort of thing.
I had a case recently that I mediated in civil harassment, and the police had been out 80 times.
Oh my goodness.
80.
Wow.
And I found that to be a high number.
That is a high
I think
number.
Previously my record was something, not my record, but it's 20 or 30 times, but 80 seemed to be a lot.
I think that is high.
So they, they refer out, yes.
Yes. Very true.
Okay, so you have an LLM, which is that Masters of Law, and that is something that I've learned from you. I think you get a JD, so you went to law school.
I went to Hastings Law School in San Francisco, and I practiced law for many years.
Oh, okay.
And then I did other things.
Many other things. All right, so you have a background in law.
Yes.
What facilitated that change, like, to get you interested in mediation? Like, because what I heard is almost like two careers.
Very much so. I started law school in 1980 when we didn't have mediation. Nobody was talking about mediation. And my goal was to be a trial lawyer. My dream was to be in front of juries fighting for justice. Maybe I saw one too many movies.
I think we all
That
have.
was the goal. And there was one little course on negotiation and settlement. That was it. I took it. I didn't think much of it because I wanted to fight in court and win. One of my classmates, actually someone a couple years ahead named John Landy, who is now a leader in the field of ADR in every way. People should read his books. John Landy, Lande.
And so you knew him from law
I knew him
school.
from law school, and he told me that he was going into mediation. I had never heard of it. He explained what it was, and I thought, I am never going to do this. This is this is such a waste of time. It's so weak. We went to law school to learn how to fight in court.
Yeah.
I had a completely different view of him after he told me that. And well, now he's John Landy.
Yeah, now he made it into a whole career, right?
Exactly.
That's so interesting. So your immediate response to mediation then was that it was weak and irrelevant?
And not a reason I went to law school. Not a
Yeah.
reason I went to law school. But then what happened was I started working at Legal Aid, and my first area was housing, representing tenants. So I thought, well, this is great. The cases go very quickly. You can actually get into court within a couple months on every single case. I thought, I'm going to get a lot of trial experience, just what I wanted. Well, what actually happened is that the lawyers who had been out a lot longer than I had on the other side taught me how to negotiate. So they filed their complaint. I
Okay.
filed my answer. I'm getting ready to depositions and interrogatories and the whole catastrophe on these little kids. And they thought it was kind of cute, I suppose, that I was taking this so seriously when we could just work it out by phone.
Yeah.
So little by little, I saw the benefits of just calling them up and
Right.
working it out. And the main benefit was for my clients. Because I could hear what they actually needed, which was not exactly what the court could award.
Yes.
Even if we won,
Right.
we would miss the mark.
Right.
So this happened in a very natural, holistic way, kicking and screaming. But I finally saw that for very practical reasons, I could represent my clients in actually stronger, better ways than just going to court. Even if I won, it wouldn't be as good.
Right, and I have heard that many times as a mediator in court myself, where even the judge might say that, to say, I suggest mediation where you'll have better outcomes than something I could decide or won't be able to decide.
Exactly.
And so sometimes I hear judges, to your point, to make that kind of comment.
Well, I had to learn the hard way.
You kind of have you had the boxing match with the concept, I guess.
Yes, I very much so.
Yeah,
very
so
much
that's actually very interesting. I didn't know that about you. So you got into ADR, and I'm using that as a very broad term.
Yes.
What kinds of things have you been doing in that after that change?
Right. So after that, through my LLM program at Strauss, I found out about jobs in the courts. And that became very interesting to me, to develop court-connected ADR programs. So that's what I've been doing.
Okay, and so I know you worked in Riverside
Yes.
at some point. What did you do there?
Well, that job was fascinating because the court hadn't really had a court-connected ADR program. They had attorneys and volunteers coming in to do various mediation, but it wasn't an internal court program. So we developed that from scratch. It was very satisfying and
So I
fulfilling to
guess
do
help
that.
me understand what
Yeah.
you're saying. So you have attorneys and volunteer mediators, which I've seen in a lot of courts
Right.
even today. You're creating the assignment and tracking of those cases?
We did
or-
many things. One thing that was it might be quite interesting to your students who probably have been well trained to think of mediation as a voluntary process. We started a mandatory mediation program where in certain cases, parties are ordered to go to mediation.
Okay.
It's like taking the horse to water. They're ordered to the water. They're not ordered to drink. They're sort of ordered to drink. They have to participate. They're not ordered to settle. They're ordered to go to a mediation process. So we started this mandatory mediation program, and we needed to develop panels of mediators who would take these cases.
Sure.
So it was a whole court system from the courtroom to the mediation.
Okay, and then give me an example of a case that might go to that, not forced mediation, but assigned mediation?
Yeah.
Maybe is a way to say it?
Well, it's interesting. We could play with the words because in a way it is forced, but actually no judge is few judges are going to order parties to mediation when it's clear it would be a waste of everyone's time and
Right.
counterproductive. So there is a bit of negotiation about the level of mandatoriness. But
Okay.
these were cases that were valued at $50,000 or under, and
Okay.
would otherwise have been ordered, no question about it, to judicial arbitration. So
Okay.
the law in California allows for courts to enter into a program to give parties the choice in cases that are valued at $50,000 or under. You're going to judicial arbitration or you're going to mandatory mediation. Let's discuss which is best for your case.
Okay.
And most of the time people will choose mediation and the judge will order it.
Okay,
if it's
and then
offered.
if mediation fails, do they go to arbitration?
No.
Then they go back to
They
trial.
get one bite, one or the other.
Huh, and then does the disputant, do they have input into arbitration versus mediation? Or is it mostly the court administrators making that judgment?
Again, I think it's more of a mediation, a negotiation between the parties and the judge. And this is in
Okay.
courts where there's time to have these kinds of conversations. Often it's very, very quick. What are you doing? If you don't tell me, I'm going to order you to one or the other. So
Okay.
tell me. So this is a way for the judges to incentivize the parties starting to work together, even if it's just a procedural question. Which process do you want? You have to pick one.
Okay, and then who pays that bill?
Well, that's interesting. If the court orders parties to a process, the court may not order them to pay it. So it's free to the parties.
Okay,
The court, some courts pay mediators a small amount, just like they pay the judicial arbitrators a small
Right.
amount, and some courts require the mediators to serve pro bono.
okay. So then in Riverside, was it a combination or was it one kind of mediator?
In Riverside, we made the decision to pay the mediators of the same amount that we paid the judicial arbitrators.
Oh, okay.
Right. A very small amount, but it's more than nothing. Actually, this is very important to me to treat the mediators with some form of professional respect because, as they often say, everyone in the room is getting paid. The insurance adjuster, the attorneys on both sides, and not me. And it's not right. And it actually promotes respect for the process and for the mediator when it's not free.
Yeah, that's interesting. Okay. Yeah, that's very good. And so then if I wanted to be in that program, do I have to be an attorney? Do I have to have training?
Well, different courts make different decisions
Okay.
about, every court must have criteria for mediators to be on their panel. Some courts require attorney mediators, Riverside did, but some courts require a certain amount of mediation training and education without regard to whether you're an attorney or not.
Right,
Different
okay.
courts make different decisions.
So, but the DERPA standard's the same across all, I think.
DERPA may or may not apply to these panels.
Okay. Okay, so we've been talking about ADR, and we're talking about it broadly. What do you think is the most exciting part about ADR today, like from where you stand?
Well, I think there are two exciting parts. One is online dispute resolution.
Okay.
And the other is how routine ADR has become.
Okay, so let's talk about ODR. When I use that term, I'm thinking every kind of technological mediation that could happen. So I'm thinking of everything from instant messaging to video chatting to collaborative learning platforms, document sharing, kind of everything. Is that how you see ODR?
Yes, in my mind, there are two parts to it. One is everything you said, and the other is the growing use of artificial intelligence and
okay.
algorithm-based ODR. Sometimes it's a gray area where one ends and the other begins.
I heard some very big criticisms of the modeling that goes on in the law, but we don't have time to get
Yes.
into all that. But yeah, that kind of borders on that issue, which is pretty
No,
interesting.
they're very important issues and
Yeah.
fascinating issues about ethics and assumptions and who's
Yeah.
creating the algorithms. So we
Yeah.
have to be very careful about it.
Yeah, that's so interesting to me. You mentioned that ADR has become relied upon, I guess. Is that a way to say it?
It's just completely routine
Yeah.
for the court to expect parties to have done some kind of ADR process before appearing, and it's completely routine for lawyers to pick up the phone and talk to each other. It really wasn't like that even when I started practicing.
Okay, so so that's a pretty big stride to have it become normal, so to speak, like a normal part.
Yes, and it's so much like that. Then when you think of the letter A for alternative dispute resolution, is it really alternative?
Oh, yeah.
And some courts, the San Mateo court, I believe, is using the term appropriate dispute resolutions. They don't have to change all of their ADR materials, but they're not even calling it.
So you have to change the A, the D, the I. Okay.
Right. We
That's
can
cute.
think of,
I like that.
It is, and we could think of other uses for the A, because really it seems like trial is now the alternative.
Yeah, that's interesting.
It is.
Very interesting to think about. And I guess that's when we're looking inside the legal process. I still, however, see citizens come in and they have the old point of view.
Right.
But they have the normal processes of ADR that they are faced with.
Yes.
So then we just educate them to bridge the gap,
Yes.
right?
You know what I think we need? We have so many Judge Judy shows, so this is what the public sees.
Oh, yeah.
And what they think court is going to be about.
Right.
So where is Mediator Mary? Right?
We need a show. Maybe that's the next project.
I think that would be such a great way to educate the public about what actually happens in court.
Yeah, that's interesting. I sometimes will even say to parties in court, remember what you're about to experience is different from what you may have seen on television. And they sometimes, will allude to watching Judge Judy or something like that. And I'll think to myself, it is absolutely not going to be like that.
Right.
Because you're not going to just be able to say something or just interrupt the judge.
Right.
Or some of these other things I see on the show where I'm like, that would never be allowed.
Right. And few judges are going to be like Judge Judy in real life.
Right. And so that's where that differentiation. But I find that for me, as a mediator, there's just that educational arm where you just take that citizen and you say, you aren't aware of this process, which is fine. Let me help you understand it so you can make your choices.
I completely agree, but I wish you didn't have to do it so much. I wish that it were out, the videos were out there for public.
Yeah, bring it to the high schools. We joke in my courthouse, we joke about all we really need to do is take high school seniors and have them go to court for a week, and then they'd know everything they needed to know. Just, you'd see things you should never do, things you should never say, that what mediation is, what arbitration is, like all that, you'd understand what we're doing.
That's a great idea.
So we've said that, but we just don't have time to do all that. But for me, when I heard you say that, I kept thinking to myself, well, that's that old U.S. history class that needs updating.
Right.
Right. And I'm not saying history isn't history. There's certainly that part. But it's like when we talk about what we currently practice, in terms of the court system and how it functions and all of that, ADR makes sense to include in that conversation.
No, it absolutely does. No, I'll tell you, at the Riverside Court, I used to attend a hearing where there would be a lot of self-represented parties in the audience ready to go up and be assigned out to trial. And I started this program of taking all of the self-represented people in the hallway before the judge came on the bench and explained to them that the judge is going to ask them if they've tried negotiation or mediation, and if they haven't, to start with a mediator. And we had a volunteer mediator sitting in the jury box waiting to be matched up with them. So I needed to prepare them mentally and emotionally that the judge is going to strongly encourage, which is very close to ordering, but not quite, a mediation process before being sent out to trial. So they're all pumped up, ready, Judge Judy style, ready to go to trial. And I needed to get them to calm down and see the benefits of it. And that actually worked quite well. But I thought, we shouldn't have to do this. Why is this not out in the public more?
Now, from my experience, I feel like all the judges I've worked with have been pretty favorable toward mediation.
Yes.
Is that what you would say?
Absolutely.
Okay.
Mediation or negotiation, just go out on the hall.
Right, because sometimes people do actually broker their own deals before we even get there.
Yes,
on some occasion.
Well, right, and there's nothing like an open courtroom with a judge waiting for you to inspire.
How do you feel about getting busy now?
Exactly.
Right? Sometimes I think about that. I'm like, I'll hear parties say, oh, we decided to agree on this dollar amount last night. Or, and we just need you to write it up for the stipulation. And I'll think to myself, this court case has been going on for 6 months, and you decided last night.
Right.
And it's sort of like this imminent facing the judge stimulates, like, now we're going to have to do something.
Exactly, but not only parties, there are plenty of lawyers.
Yeah, yeah.
who had a bad weekend, and Monday morning,
Here we
things are
are.
looking different. Yes.
Yeah, here we are. Okay, so let's talk about attorneys. As an attorney, I would love to get your thought on what do you think about attorneys in mediation, and what are your recommendations to new mediators on how to handle those attorneys? I have given my own point of view often on this show.
Oh.
Would love to hear yours.
Well, I'd love to hear yours, but I'll tell you what I have learned the hard way. As a mediator, when there are attorneys representing parties in the room, the number one rule is to respect the attorney, particularly in front of their client, and for the opposing counsel as well. There needs to be some deference. After all, these folks have spent years on this case. They know more about it than you do, and they need to be respected. Plus, they're making themselves vulnerable. They're taking a big risk by being in there in intangible and tangible ways. They know how to try a case, and now they need their clients to respect them and to know that they have their best interests at heart, and that they're being vigilant, vigorous advocates. Zealous advocates is the term for their clients.
Right.
How to do that in mediation is not as easy as it may sound. So any mediator who's on a high horse and not willing to respect the attorneys for their participation in the process is not going to be successful. So that's number one. And any issues need to be done in caucus, away from clients and away from opposing counsel.
right.
So that is my, yes, I'm sorry.
You're just saying, so use that caucus. It's something I've said, only use it strategically. In this case, strategically to save face for
Yes.
the attorney, but also to secure the integrity of the case or the evidence, whatever, like what might be shared.
Yes, absolutely
Yeah.
that as well. But I think the face saving is really key. So if you have some issue with an attorney, do not disrespect him or her in front of the client or the other side. There's no point in continuing the process
Right.
if that has happened, and you will lose the trust of that person. So although you're especially for new mediators, know your place.
Right.
These folks have more experience. They know you may know the mediation process. Congratulations, but have some respect. The other thing I was going to say is try to help teach the attorneys to help you do your job. So I would find out, and again, this could be done in caucus, how can I help you? What do you need from me? You might find something very surprising that the attorney is ready to settle, but the client has unrealistic ideas. So the attorney
Yeah.
might need your help doing reality checking with the client,
Right.
right? You might find out that the attorney might be willing to settle, but there's some issue he or she hasn't been able to bridge with the other side, and they need answers to certain questions from the other side. How can you help them get the information
Yeah.
they need in order to do it? So one way is to think of yourself as a mediator as someone who can help the attorneys use you properly
Right.
and effectively.
Right. Yeah, that's very interesting. Okay. That's very useful. Yeah. Do you have a philosophy of mediation, and how does it show up in your mediations?
I have a few philosophies of mediation, and they've changed over the years, and they're probably still changing. So that's one philosophy
Probably.
right there.
That everything will change.
Everything's are changing.
I guess that's your whole
evolving.
career too.
Evolving, yes, it
Right.
is, and you too. There's an
Yeah.
evolution involved. But one of my philosophies, it's still a hypothesis, is to think about mediation as facilitated, principled negotiation.
Okay.
So what that means is it means less is more in a certain way. That one of my jobs is to help the parties negotiate. Not just any kind of negotiation, but a principled negotiation. I brought my special guide, Getting
Yeah.
to Yes. So if mediators could study this book and study negotiation
Right.
and help the parties do what this book says, I think that would be a great way to be a mediator.
And we talk about some of those principles. I feel like you almost have to, in a way, because there's so much at the core, like not doing positions versus interests.
Exactly.
I mean, some of the things in that book, and our students certainly have had negotiation as its own class as well. So that is kind of trying to fill that in, but I feel like in practice it has to be there.
It has to be there so that you are helping the parties facilitate their own agreement, and the less you do, the better. Can I just tell you a quick story?
Yeah, I'd love a
My
quick story.
very, very first court-connected mediation at the Santa Monica court, when I was doing my LLM program at Pepperdine, I had this externship there, and I was ready. You better believe it. I had my opening statement. I had the briefs. I had a briefcase. I had a suit. I was ready. And I knew all the phases and the processes, right, ready to go. The first thing one of the attorneys, there were about 5 attorneys. One of them said to me,
For your first
Yeah,
case.
exactly, no problem. That's what you were saying before, be ready for anything.
Yeah.
The attorney said to me, Barry, I think we can work this out. Let us try, but we need you here. So I sat at the head of the table, and all these attorneys just started talking. We can dismiss this person, we can dismiss this case, these things need to go to arbitration, these things we can talk about some other time. And they said, okay, got it? Okay, thank you, Barry. You're gonna get the highest evaluation because you stayed out of our way. But they needed me there, they could not do it
Right.
without me there. So I thought, if anything is less is more.
Wow.
This is
That's
it.
your first mediation?
Yeah, my first court-connected mediation. And it's been a valuable lesson for me.
Yeah. Yeah, that is interesting.
That's what they needed.
Yeah, right.
Who am I to call a mediation with an opening statement and the phases and the ground rules?
Hey, that's all still important. The training's important now.
It's very important when needed.
Right, and what you and I talked about outside of the show today is this notion that while all of that training is crucial, all of it is important, reading, getting to yes, all those things, all that training is great, there is additional flexibility that has to happen as you implement those ideas or concepts, and if you don't have the flexibility, you're in trouble, which is what I learned from your story.
Absolutely right. I mean, that is a philosophy of mediation. The philosophy is to question your philosophy.
I had one time I was in a civil harassment case and I had students observing me, and it got real crazy with the first disputant. And so she got very angry and started yelling, and lots of different things happened. And so we were in a caucus format, and so she left, and I turned to my students and said, "What will happen next?" And they all laughed and said, I don't even know what to say. And I said, I don't either, but we're going to
Right.
figure it out. And what we're going to do, and this is my philosophy, I'm going to help them get to a better place than when they arrived at the court.
Oh, yeah.
And that is my number one goal the whole time. And then that helps me handle mistakes, and it helps me handle when I thought it should go one way and it needs to go another way. Because if I'm focused on the benefit of that citizen, then I
Right.
have the focus to be able to have that flexibility, right?
Yes,
Because
exactly.
in the next moment, what you might need from me is like what they needed from you. They need you to be the mediator, but also to help them, manage this. And it was different than what you thought.
Exactly.
But I do love that that was your first mediation. Okay, so I train mediators all the time, over 100 a year. I know, it's crazy. What do you think is the hardest part for a new mediator to learn? When we talked about flexibility, maybe that's one.
I have to say it's something you can't teach. It's the experience.
Okay.
The experience and well, maybe you can encourage some humility.
So we're not always right? Is that what I hear?
Saying we're not always right, we don't always know what's best. Tread carefully. Focus on questions rather than answers. Asking rather than telling as much as possible, I think helps you stay on the right path.
Right.
Maybe assume that we have some biases and assumptions and work we need to do in ourselves rather than be defensive about it and knee-jerk, no, of course not, I'm completely neutral,
Right.
really. I just
Well, we have to check that one all the time, right?
Right, and there is a book that should have come before this book, but actually came after, called Getting to Yes with Yourself, which is very helpful for mediators also, to turn this around and look in the mirror when we attempt to help others.
Okay, so experience and perspective, is that what I hear you saying?
Absolutely.
Okay. Well, so that means for everyone to get out there and mediate then, after being trained, right? Which I believe in, just because it seems like experience is the greatest teacher.
That is so true. And I would also say that one thing a practice that new mediators could start, and I'm not saying I do it perfectly, I certainly don't, is to not think of yourself as an on and off button. Okay, now I'm mediating, now, which is great if you can do it, but why only then? Why not always be practicing questioning one's assumptions, looking at oneself, active listening with others, so that when you sit down at the head of the mediation table or in the circle, but probably we have circles, not heads, it's completely natural because this is how you always communicate.
So then it's no longer work, it's normal.
Exactly.
Yeah, very interesting. Advice for our new mediators?
I think that was my advice.
Oh, is that-
actually, I think that I'm.
Maybe I asked you that. I think I
do
did
no
ask you
harm.
that.
Well, it's actually a philosophy and advice. It kind of
Okay.
goes together.
Yeah.
You know, do no harm. Be humble. Assume people know what's best for them and need some help getting there.
And one thing that I talk a little bit about is compassion also helps.
Absolutely.
Right there. So I've said this on other shows, one of my philosophies is to think, you know, I can look at this disputant who knows nothing about the law, who didn't do the research, brought all the wrong documents to court, which happens all the time in mediation, you know, where they are missing like the most important document. And I can look at that and say, wow, that's bad for you and that's bad and, you know, you should be better and look down my nose. Or I can say, gosh, I'm going to have compassion for you. Because sometimes I think to myself, that's why you're here.
Right.
Because you have some difficulties getting all of this to work.
Right.
And so let's get you to a better place. And I'm going to do my best to be neutral in that and facilitative and, you know, all the things that are part of my role. But at the end of the day, I'll try to have some compassion to do that work so that you're better.
No, that is really important and a beautiful thing. And all I have to do is think about myself going to the car mechanic.
Me too.
And how they make me feel, how they have the opportunity to make me feel one way or the other. And that helps me recall that this is my life, it's not their life.
Right.
And how I know how I like to be treated in places where I'm not comfortable or familiar. So that can help.
So that's good. Those are some good thoughts for our mediators. Well, thank you so much for being on the show today. Very interesting to learn about ADR from you. We appreciate you being here.
My pleasure. I enjoyed talking with you.
All right. Thank you so much. So that concludes our show today. We talked about stage 5, writing the agreements and settling. We talked about some elements of that stage. We talked about ODR, and then we were able to hear from Barry Roberts. So hopefully all of that was valuable for you, and we'll see you next time.